Assalamu alaikum. Welcome back to Hilaal Live. Thanks for joining us on channel 347, also on our live stream, www.hilal.tv. Tonight's discussion is about deceased estates, and we all know that if you have the proper planning in place, it can become quite easy, but if not, it can become quite complicated. So I thought let's invite our good friend back into studio, attorney Fazloodien Abrahams. Assalamu alaikum.
Alaikum salam, Lukman, and shukran for having me again.
My absolute pleasure. Thanks for making the time. Such an integral part of our estate planning and part of our community sometimes gets miseducated about a deceased estate. But what are maybe let's start, what are the key principles of an Islamic inheritance, and how does that differ from our secular laws or estate planning?
So in South Africa, we have something called freedom of testation, meaning that the testator, the person making the will, has the right and the freedom to stipulate in the will who the beneficiaries are, who inherits the estate.
Right.
Whereas with Sharia compliant will, with Sharia, the Quran stipulates, it's in the surah, and it's quite clear. There's no, it depends on the levels of generation, who inherits, and the marriage and the legitimacy of the child that is born from the marriage. All those things has an effect on it.
Yeah. So when one makes out, the testator makes out a will, they need to stipulate that it needs to go by Sharia principles. If not, it then gets divided according to South African law.
So when we speak to a client and the client insists that he wants a Sharia compliant will, we have to advise him at least what the outcome would be, what the distribution would be of the estate. And once he's comfortable with that, he will continue and say Sharia compliant. Now, part of the will is drawn up in a way that it stipulates that this is a Sharia compliant will, and what the requirement is that the executor would have to request from the ulama body, who has authority in the region, to issue what we call a certificate of distribution. And that certificate of distribution would be by a learned scholar who have consulted the Sharia rules and regulations, and they will then issue and stipulate exactly what percentage each one would be inherit, those lawful heirs, obviously.
So we've got the WhatsApp line open if you'd like to contribute or you'd like to ask a question. Maybe you've got a challenge at the moment. Brother Fazloodien will try his level best to answer that. 079-085-2511. WhatsApp's only, no telephone calls, if you have a question that you would like to ask our guest. So let's start with the basics. When we're filling out the will, what are the very important information that needs to be put in the will so that it is legitimate?
Firstly, the testator needs to be clear in terms of his identity. So name, surname, ID number. If he owns any property, would stipulate the earth number and the address of the property, together with the marital status. That's important. Then what we look at secondly would be the executor. You would have to stipulate who would become the executor, and even so a substitute executor.
On that question of the executor, I just want to stop you right there. Sorry to break your words. Can a beneficiary also be an executor?
Yes. Nothing wrong with that. A lot of people are confused whether a beneficiary would be any conflict of interest being an executor.
That's where I'm coming from.
Not at all. Not at all. An executor is entitled to be a beneficiary and vice versa as well.
Brilliant.
So after the executor has been stipulated in the will, he needs to deal with the beneficiaries, or at least in this case, a Sharia compliant will. Do not speak much about who the beneficiaries are, because the certificate of distribution issued by the ulama, the authority, would stipulate who the beneficiaries are. How is that determined? You submit the marriage certificate, the birth certificates, the ID documents of the family, the direct family, and the person who's in charge at the MJC, for example, or any other ulama body, they will then issue what we call a certificate of distribution. Now, what is important is that you find in our communities where we have an individual who maybe had a child before marriage.
Okay.
And as a result of that, that child is not allowed to inherit.
Okay.
You also find children who are adopted who is not allowed to inherit in terms of Sharia.
Right.
So therefore, the testator would be entitled to issue up to 1/3 of his estate, what we call a wasiya. And that portion would then be issued or distributed to that person mentioned there. So it can be specific. It can be an item. It can be an amount of money, but up to 1/3 of the estate.
Okay. What happens in the event of divorce? Obviously, maybe somebody was married twice. The children from the first marriage then become beneficiaries.
So in the event of a divorce, your divorce order would stipulate who receives what portion of that estate.
Okay.
Either they are co-owners and each one is entitled to 50-50, or where they are not co-owners and the one person is the registered owner of the property, he would then, after the process through the court or even at the MJC where there's a talaq or fasakh, that arrangement, or even in court now, because these the Islamic marriages, the Muslim marriages, are allowed to be adjudicated in our courts today.
Right.
And that settlement agreement is ultimately what will determine who receives what portion in that estate.
Okay.
Now, as a result of that, your will still stipulates who is your lawful heirs, right? So who your lawful heirs are. And ultimately, if you're not married anymore, then it's your children. But if you're married, your spouse and your children, if there's no son, then your siblings would also inherit.
Okay.
But if you do have a son born legitimately from the marriage, then your children would inherit and the spouse. If your parents are alive, it depends on what who's all alive at the time of death.
Right.
And they will then be entitled to inherit.
Okay. On the WhatsApp line, 07908525111, if you'd like to ask us a question, maybe there's a challenge that you're struggling with at the moment, and there's one or two coming through, and I'm going to get to those WhatsApps very shortly. Fazloodien, as part of the estate as well, people would have debt and liabilities. They could have various amounts that need to be paid and handed over as well. Is it the role of the executor to ensure that these amounts are paid?
Indeed. That is exactly what his responsibility is to take control of all the assets, liquidate whatever needs to be liquidated in order to create a cash flow, if necessary. If there's enough money in the bank or funds available to pay the liabilities, then that's fine. You don't have to sell any of the assets off.
Right.
The first page in what we call an L&D account is called the liquidation account.
Okay.
Liquidation account consists of your assets stipulated with its value, whether it's sold or not, and then below that, the second part of that is called the liabilities, which is further broken up into two parts.
Okay.
The administration of estate expenses,
right.
And the second part of that is called a claim against the estate.
Okay.
So
that's
claims,
where that gets sorted out.
That's where the creditors are paid and any other liabilities owed to other parties or third parties.
Right. So this is the situation where there is a will. But what happens if there's no will? Do we go according to South African law then?
Correct. We have in South Africa we have something called the Intestate Succession Act.
Right.
And that particular legislation stipulates who will inherit what.
Okay.
Whether there's a spouse, a surviving spouse, the children, descendants.
And everything gets distributed equally then?
It depends on whether there's spouse and what the marital relationship is. Yeah.
Okay. Yeah. That therein lies can be issues as well, because it has to be back and forth with the masters. All the relevant paperwork needs to be submitted, and it can take a while.
Indeed. It takes about 5 to 8 months. If there's any complications, then it could take longer than that. But the usual process, without any hindrance, you're looking at about 5 to 6 months.
Sure. That's still quick. I think, I've heard people struggling for years.
No, we have incidents at our law firm as well where there's complications. Either the heirs they cannot come to a solution.
Okay.
Their dispute is ongoing. Something goes wrong at the masters. The file is missing. They can't find the file. This is wrong. That's wrong. It's a whole lot of things that can really go wrong because there's a lot of processes, quite intricate processes, that's involved in the administration of estate.
Yeah.
And that causes a delay, really.
Of course. When it comes to the interstate part of the will, do you advise for the family to then maybe get a lawyer to get involved, or can they do this themselves?
The minute the value of the deceased estate, gross asset value, is more than 250,000 rand, you need to get an attorney involved.
I see.
It's compulsory to have an agent
Okay.
to represent the executor and do everything that is necessary in accordance with the law.
Right.
To ensure,
And these fees, I mean, can be exorbitant at times as well. Can this be negotiated with attorneys?
According to legislation, never negotiate with an attorney, you're going to lose.
Yeah.
But according to legislation, 3.5% of the gross asset value is the going rate at the moment. Yeah.
Okay, that's very good to know, because I've heard stories where it's been dragging on for months and years, and the fees are just piling up. And unfortunately, not everybody's estate is over 250.
Yeah. A lot of people don't realize that the administration process is what you are allowed to charge for 3.5%.
Okay.
The minute there's disputes between a creditor and the executor or heirs amongst themselves, that requires additional consultations. And that is where the additional fees comes up. Yeah.
On the WhatsApp line, 07908525111, we've got one or two WhatsApps come through. We're going to get to that after the break. Do join us if you have any questions, you have any burning concerns that when it comes to deceased estates. That's what we're discussing today. And we've got Fazloodien Abrahams in studio, who's going to try and answer those questions for you. Do join us after the break. Thanks for watching us on Channel 347. Assalamu alaikum. Welcome back to Hilaal Live. Thanks for joining us on Channel 347. Tonight's episode, we are talking about deceased estates, and in the studio we have attorney Fazloodien Abrahams. Jazakallah so much for coming in and being part of the program.
It's a pleasure, always.
So one of the WhatsApps that's come through, and then maybe we can touch on that. I'm sure the viewer is probably waiting in anticipation for an answer.
Sure.
It reads as follows. Assalamu alaikum. Jazakallah for an informative program. In a case where one has no children, can one leave an asset to a niece or nephew instead of siblings?
Shukran for the question there, viewer. We have something called freedom of testation in South Africa.
Okay.
So the testator is allowed to bequeath his estate to anyone.
All right.
That is according to South African law. However, Sharia is quite clear that they will stipulate exactly who the lawful heirs are.
Okay.
Yeah. So you can, if it's question, if it's non-Sharia, but if it's Sharia, no, you don't get to choose who inherit your estate.
All right. Okay. Shukran for that. Jazakallah for that, viewer, for sending us that question. As part of it, and you welcome other viewers to send any questions, 07908525511, and we'll pose those questions to Fazloodien. When it comes to estate duty, we often hear this phrase thrown around as well, but what is the legal standing when it comes to how estate duty is calculated on a deceased estate?
So you start off with a basic, right? And that is the gross asset value. And then you're allowed to deduct certain items like your liabilities, and also what we call the Section 4Q allows for certain deductions from the estate. And there are certain policies that is allowed also to be added on.
Okay.
And once you get to your net figure, that net figure, if it's anything above 3.5 million rand, and that is what we call an abatement figure, right?
Okay.
That the government allows you to not be taxed on for estate duty purposes.
Right.
So, for example, if the net value after doing the calculation amounts to, let's say, 4.5 million rand,
right,
the 3.5 million abatement figure is deducted, and you're left with R1 million that is taxed at 20%.
I see. Okay, 20%.
I almost said 100,000, but 20%, 200,000, 100%. That is what is done. I think a lot of people, it's a fright.
Yeah, a lot of people don't cater for that.
They don't.
Don't understand that is how it works. And estate duty is on every property, and if you have additional properties as well?
That's your gross asset value. That consists of your immovable property, your motor vehicles, your money in the bank, after deducting the liabilities, adding any policies that was on your name, or any beneficiary that received the policy, those premiums, anything, fiduciary benefits are allowed to be added. The good thing is that if there's a surviving spouse, the inheritance the surviving spouse that receives out of your estate would then be deducted, but not the descendants, not the children.
Right.
That would be deducted from the value, and you get a net figure. That net figure, if it's more than 3.5 million rand, will be taxed at 20%.
Speaking about liabilities, just want to bring back to the point as well. So what happens, the husband passes away, Allah forbid, and the wife is now left with the estate. And when it comes to debt and collections, is the wife also responsible for part of that as well, or just the husband's estate?
Remember, the spouse as a beneficiary in the estate ultimately receives what's left available for distribution.
Okay.
The executor has a responsibility to ensure he takes control of the assets, collect, and what we call Section 29 advert is placed in the Government Gazette and the newspaper,
Right.
where he calls any creditor or third party who's owed money by the deceased and to come forward and put in their claim.
Right. Okay.
Together with all the administration expense to administer the estate, that those costs are paid by the estate itself.
Okay.
And if there's no money to pay
Yeah.
those costs, then the heirs would have to pay in order to receive the immovable property or the movable items.
Okay, gotcha. All too often we do have things like investments, insurance policies that the deceased has now left behind. How does that get distributed? Also gets calculated within the estate?
So when we talk about the assets, we talk about three items. It's called the immovable property. Those are the homes, the houses that they owned. And then you have the movable items, which consist of the furniture, fixtures, and fittings, your household effects, your motor vehicles. And then the third item under the asset division would be claims in favor of the estate.
Okay.
And that's money in the bank, policies collected from where there's no beneficiary.
Okay.
So if there's no beneficiary listed in the policy, the money will automatically be paid into the estate.
Okay, gotcha. You're welcome to send us a WhatsApp on the WhatsApp line 079-085-2511. WhatsApp's only, no telephone calls, unfortunately. If you have any query with regards to a challenge that you're facing in a deceased estate, or if you have an issue or problem or a question that you would like to ask our guest, you're welcome to send that through right now. Sometimes you do get disputes when it comes to a will. So let's take the example where the will is stipulated that it has now been drawn up according to Sharia law. Who then adjudicates any disputes?
Part of the document known as a Sharia compliant will usually will contain a clause that stipulates if there's any dispute among the heirs, then that dispute needs to be adjudicated by the ulama body who has authority over the region. In this particular instance, let's say, for example, Cape Town, it would be the MJC, and whatever decision they reach would be final.
Okay. All right. Okay, that's very interesting as well, because lots of people may not understand how that works.
Yep.
So what is your advice? If somebody feels, say a couple that's just got married, or someone that's been married for a long time and they would like, don't have a will, they would like to draw up a will. Let's speak on behalf of our Muslim viewers first. What would you advise them to put into the will so that there are no complications going forward?
Nothing much except for having a will drafted, because the will is Sharia compliant. They don't have to worry about who receives what. The only thing they need to be concerned of is who will be the executor.
Right.
Why I say so is that the law of the land allows for an estate to be distributed either intestate or according to the will.
Right.
Now, if a will is non-Sharia compliant, you will end up having an issue with the children, or you would have an issue with your maker at the end of the day, and nobody wants that.
Yeah.
So it's quite simple. Consult an attorney, listen to what the options are, and make a choice. The choice that you make would ultimately have consequences for you either in the year or the year after.
Right.
And for many of them, they don't realize that there are regulations in place that actually solves the concerns. For example, if you had a child born out of wedlock,
yes,
and you now understand that this child cannot inherit, and you feel that, you don't want the Sharia compliant will, but how do you then give something to this child? The wasiya allows for that.
Okay.
And that is where the consultation with an attorney is required to understand exactly what your options are.
Yeah, I know all too often that we've seen articles about Wills Week that we've highlighted in South Africa, is that you encourage people obviously to draw up a will and ensure that all their assets are recorded correctly, and that when it comes to distribution, that there's no hiccups as well. Have you find those initiatives worked well over the years?
It's an excellent initiative. It always helps. It brings about people to take the responsibility to have their wishes placed on a piece of paper. That really creates ease for the family members, but also creates ease for them.
Right.
I think it's something that should be continued forever. Yeah.
In your experience, have you had many challenges with deceased estates? Off the top of your head, what are some of the things that you feel could have been avoided if a will was drawn up correctly?
You know, don't consult someone who is not knowledgeable in what the clauses should be, how to draw up a will, what the consequences are, knowledgeable on marital regimes.
Right.
So I wouldn't go to a normal commissioner of oaths who does not understand the concept of inheritance and also the consequences of the different type of marital regimes,
right.
Divorces, children, legitimacy, Sharia compliance, because that is where we find problems.
Okay.
The will is either vague as a result of that. You don't know whether to interpret it this way or that way. You find that it's an invalid clause. For example, the testator is not allowed to rule from the grave,
Yes.
where they say that you can only receive this item if you don't get married.
Right.
Now,
right,
it's an unlawful clause in South Africa, which means you can't enforce it now, and that creates issues as well.
Wow.
Yeah.
Well, I hope for our viewers that this program was informative, and I'm sure that can someone go discover or find it a bit more on a particular website? Are there social media pages that people can go to just answer some of their questions?
Sure. We have a website. It's called www.sa-inc.co.za.
Okay.
Or for ease, it's one of my websites. It's a quite easy one. fazlaw.co.za. That's where people can go up. And I have videos, almost like tutorials,
right.
that explains the process of administering a deceased estate. And there's a lot of reading material as well for the wills. As to, look, you have various kind of wills. You have a joint will, single will, mutual will, living will, and you have a Sharia compliant will.
Brilliant. Fazloodien, it's been a pleasure. Have a great evening. Assalamu alaikum.
Thank you for having me.
My pleasure. There we go. That's our legal slot, chatting about deceased estates. I trust that it was informative to you. That's all that we have for you. Well, tomorrow will be a special edition. We broadcast in from the Nasheed competition at City Hall, so do catch us live from about 4:30 onwards, inshallah. That's tomorrow and Sunday. From the Cape Town team, Sohail Barnes, myself, Luqman Shadrack, and Mohammed Parker, we wish you a great evening. Assalamu alaikum.